A file opened in a Los Angeles courtroom in 2009 is still open in 2026. It belongs to a man who did everything the brochures told him to do. He hired the lawyers. He signed the living trust. He named his mother and his children. Then he died, and almost none of it worked, because the trust he signed was an empty box. So today, let's talk about the part nobody explains at the signing appointment, how your assets actually get inside one. Here is what you are really buying when you buy a trust. You are buying a container. Signing it builds the container. It does not put one single thing inside it. Michael Jackson's estate was worth roughly $500 million. He had a revocable trust drafted for his mother and his 3 children, and he never moved most of his assets into it. He had a pour-over will too. The safety net everyone gets told will catch whatever falls through the cracks. Pour-over wills go through probate. So the estate went to court, and his family fought his executors in public for years, and more than 15 years later, that trust reportedly still has not been fully funded. 20% of the estate was supposed to go to charity before a single heir was paid $1. With the values in dispute, nobody could even calculate the number. Now you are thinking, fine, that is a celebrity problem. It is not. In 2026, 56% of American adults have no estate planning documents at all. Not a will, not a trust, not a power of attorney. Well, ownership actually fell from 31% to 26% in a single year. And 42% of Americans say that if a family member died today, they would have no idea what to do next. Here is what that costs in real money. A house left out of the trust goes through probate, and probate runs 3 to 7% of the value of the estate. In California, a $1 million estate outside the trust exposes your family to roughly $46,000 in statutory fees. The deed that would have prevented all of it costs about $103 to record in Los Angeles County. Put those two numbers side by side. That is the entire video, right there. And before we go asset by asset, understand what funding buys you while you are still breathing. Because everybody frames this as a death document, and that is only half of it. If you have a stroke tomorrow, the assets sitting in the trust are already under the control of a successor trustee you picked, on the terms you wrote. The assets sitting outside of it are not. Those may require a court to appoint someone to manage your affairs, in a public proceeding, in front of a judge who never met you, with lawyers billing the whole way. Funding is not paperwork for your funeral. It is the difference between your spouse writing a check next Tuesday and your spouse filing a petition. So let's go asset by asset, and we start where the money usually is. Your house. Funding real estate means a new deed that moves title from you, the human being, to you, the trustee. Signed, notarized, recorded at the county. That last word is the one people skip, and a deed sitting unrecorded in a desk drawer has funded absolutely nothing. Then comes the question I get every single week. I have a mortgage. Will the bank call my loan? The Garn-St. Germain Act of 1982 says no. Federal law bars the lender from enforcing the due on sale clause when you move your home into a revocable trust, as long as you stay a beneficiary and keep living there. But listen to the limits inside that sentence. It does not cover a transfer into an LLC, and it does not protect a landlord moving a rental property. Bank and brokerage accounts come next, and these are the ones that quietly get missed. You retitle the account into the trust's name, or you name the trust as the beneficiary. The institution will ask for a certification of trust, which is a short document proving you are the trustee without handing a branch employee your family's private instructions. Use it. And understand why this one matters, because I have watched it happen. A couple did everything right on the hard stuff. They deeded the real estate. They assigned the business interest. The account forms were never finished. They died within a year of each other, and their son inherited 2 things: grief and probate. Then there is everything with no paperwork behind it. The furniture, the tools, the rings, the paintings on the wall that your kids are going to remember better than the balance sheet. Those move by a general assignment of personal property, 1 page, signed once, sweeping the untitled stuff into the trust. Attach a schedule if specific items are going to specific people, because I promise you, the fight is never about the brokerage account. It is about the ring. Vehicles are their own animal, state by state, and a safe deposit box needs the trust listed on the box itself, not just a key in a drawer, or your family gets to explain their relationship to a branch manager who does not care. Possession is not ownership. A key in a pocket proves nothing to a bank, and a title in your own name proves everything to a probate judge. Now stop. Because this next one is where people torch their own retirement trying to be organized. Do not retitle your IRA or your 401k into your trust. You cannot. Federal law requires individual ownership, and the attempt gets treated as cashing the entire account out. Ordinary income tax on the whole balance, plus a 10% penalty if you are under 59.5. Imagine writing that check because you were trying to be responsible. The correct move takes about 4 minutes. You name the trust as the beneficiary, not as the owner. Even then, read the trust language carefully, because the IRS finalized the 10-year payout rules in July of 2024, effective for distribution years starting in January of 2025. And if the trust holds that money instead of passing it straight through, watch the brackets. In 2026, a trust reaches the top 37% federal rate at around $16,000 of retained income. An individual does not get there until roughly $640,000. The same logic runs through life insurance and annuities. Nobody retitles a policy. You control it with the beneficiary designation, and that little form outranks your trust, outranks your will, outranks whatever you told your family at Thanksgiving, which is why funding day is really coordination day. Pull every beneficiary form you have ever signed and read them out loud. The ex-spouse, the parent who passed in 2011, the blank line nobody ever filled in. I have seen a death benefit land in the hands of somebody the deceased had not spoken to in 2 decades, and there was no argument to make, because the form said what the form said. Business interests are where careful plans go to die. Whether your transfer actually works has almost nothing to do with your trust document and everything to do with the entity's own paperwork. Operating agreements, buy-sell provisions, consent requirements. In a lot of states, the default rule is that your membership interest cannot move at all without unanimous consent from every other member. And there is a second trap sitting underneath that one. An assignment often carries only the economic right, the right to receive distributions, while the voting and management rights stay exactly where they were. Picture your successor trustee holding the money and locked out of running the company. One family hit that wall, amended their operating agreement, signed separate assignments, and updated the state record. 2 months, start to finish. Done while everybody was still alive to sign. Then there is the gap almost nobody has closed. 48% of Americans have no instructions whatsoever for their digital accounts, and even among people who already have a trust, 11% have none. Most states have adopted the revised Uniform Fiduciary Access to Digital Assets Act, and under it, your trustee can reach digital property only if your documents say so out loud. Without that sentence, privacy law and terms of service can lock your family out of accounts everyone knows exist. And self-custody crypto does not negotiate with anybody. Access lives in a 12 or 24-word recovery phrase, or a PIN. There is no password reset. There is no court order that works. Many devices erase themselves after a handful of wrong guesses. Somewhere tonight there is a drawer with a hardware wallet in it and nobody left alive who knows the words. Now let me argue against myself for a minute, because you deserve the whole picture and not a sales pitch. A revocable trust gives you no asset protection while you are alive. Creditors can still reach those assets. It saves you nothing on your taxes today. And if your entire estate is one house and a checking account, a transfer on death deed might be all you actually need. The California Attorney General says it plainly. Not everyone needs a living trust, and anybody selling you a one-size-fits-all trust kit is a red flag. That same office spends its time chasing what they call living trust mills, outfits that sell defective plans and unnecessary annuities to seniors in church basements and assisted living dining rooms. And their final piece of advice is the same as mine. Make sure whoever you hire actually funds the thing. Which brings up the question you should ask before you pay anybody $1. Not what does the trust cost? Ask who records the deed, who sends the letters to the banks, who chases the beneficiary forms, and who calls me in 90 days to confirm every single one of them landed. If the answer is a shrug and a binder, you have not hired an estate planner. You have bought a very expensive book. And if you already own that book, this is fixable today and brutally expensive later. California's small estate threshold for 2026 is $208,850, with a simplified path for a primary residence worth up to $750,000. Where assets got left out, a Hegstad petition can sometimes pull them into the trust without a full probate. But the cheap version is the boring version. A deed, a retitled account, a one-page assignment, a beneficiary form, one clear sentence about digital access. Then a second pass every time your life changes, because a plan funded in 2019 does not know about the house you bought in 2024 or the account you opened last spring. All of it done on an ordinary Tuesday afternoon for a few $100s, while your hand still works and your name still means something on a signature line. There is no version of this that gets easier by waiting. There is only the version where somebody else does it, in a courtroom, without you. Because here's what 15 years of a courtroom file in Los Angeles is really telling you. For almost every family watching this, none of it was ever a tax problem. The federal exclusion in 2026 is $15 million per person, $30 million for a married couple. This was never about the tax code. It was about titling. It was about whose name is printed on the deed, on the account, on the beneficiary form. A trust is a box. And a box protects nothing at all until you put something in it. So go put something in it.